Is election to Congress a license to libel? That is how Robert Barnes, attorneys for the Covington Catholic Kids, is framing the question. Viva Frei, Montreal litigator turned YouTuber, and there is an update in the Covington Catholic Kids defamation lawsuit. By now, you probably all are or should be familiar with the Covington Catholic Nicholas Sandmann defamation lawsuit situation. I've done a ton of vlogs on the subject. I'm not even going to give you a 30,000-foot overview. I'm going to link a playlist to the Nicholas Sandmann vlog playlist right here. Give them a watch if you don't know what's going on for whatever the reason. No 30,000-foot overview, but one clarification. There are two parallel sets of proceedings that are pending. On the one hand, you have your well-known Nicholas Sandmann versus Washington Post CNN $250 million defamation lawsuits. In that lawsuit, you have Nicholas Sandmann being represented by L. Lynn Wood. Lesser known is the entire lawsuit of the Covington Catholic Kids, John Does 1 through 8, who are suing various defendants for defamation. They're not suing for hundreds of millions of dollars, they're suing for tens of thousands of dollars. Those John Doe Covington Catholic Kids are being represented by Robert Barnes, and they are suing a number of defendants, but most notably Elizabeth Warren and Deborah Holland. Those plaintiffs are suing Deborah Holland and Elizabeth Warren for defamatory tweets that they tweeted in the wake of the entire incident that gave rise to this entire situation. And the John Doe Covington Catholic Kids recently had their lawsuit against Elizabeth Warren and Deborah Holland thrown out on the basis of sovereign immunity. Warren and Holland made a motion to transfer the file from the state court to the federal court, and they made a motion to dismiss on the basis of their sovereign immunity, and they succeeded on both motions. I did a vlog explaining the transfer of jurisdiction, the dismissal of the suit on the basis of sovereign immunity. The judge who in fact dismissed the suit was Judge William O. Bertelsmann, the same judge who dismissed Nicholas Sandmann's lawsuit against the Washington Post. It's a small world in the judicial community, but if you haven't seen that vlog, it will help you understand this one. I'm going to link that vlog right here. Give it a watch. But here are a few highlights so you know where we're going with this vlog. Well, if the precedent did not already exist, it certainly exists now. An officer or agency of the United States of America can tweet what would otherwise be a defamatory tweet with immunity, so long as there is even a casual connection between the tweet and their official position. Robert Barnes, as counsel for the Covington Kids, gave all of these celebrities and politicians who are now being sued a number of occasions to clarify and rectify their mistake. In fact, all that Barnes, for and on behalf of the Covington Kids, wanted in the first place was that the celebrities and the politicians simply retract and correct their tweets. Once the lawsuit was moved from state court to federal court, Holland and Warren filed a motion to dismiss on the basis of sovereign immunity. Both Warren and defendant Deborah Holland, who is a United States representative from New Mexico, raised the defense of sovereign immunity to plaintiffs' claim against them. How did anyone think Judge Bertelsmann was going to come down on this? Thus, the crux of the issue for the applicability of the FTCA is whether the party was acting within the scope of her office or employment for the purposes of the Westfall Act. In Kentucky, scope of employment is a determination that focuses on the motive of the employee in determining whether he or she was acting within the scope of employment. The employee acts within the scope of his employment when his purpose, however misguided, is wholly or in part to further the master's business. Thus, if the servant acts from purely personal motives which are in no way connected with the employer's interests, he is considered in the ordinary case to have departed from his employment and the master is not liable. And further down the page, the judge concludes as follows. For these reasons, plaintiffs have failed to identify any waiver of sovereign immunity for their claims against defendants Warren and Holland. The defendants must therefore be dismissed. From what I understand, the decision itself is going to be appealed in one form or another, and I will bring you any updates that I have as soon as I have them. I would also love to do a follow-up live stream with Robert Barnes later on to discuss all of the developments, and I think he may agree to do that. The Covington Catholic Kids lawsuit against Elizabeth Warren and Deborah Holland was thrown out. They vowed to appeal, and they did in fact appeal, and yesterday arguments were made before the Court of Appeal, and I have the audio of those arguments. It's a fascinating thing to listen to on the substance of law, on the practice itself, how lawyers address judges, and how the whole thing works in court. It was done by Zoom or Skype or telephone, not in person because of the whole My Sharon Osiris thing, but it's fascinating to listen to nonetheless, so let's listen to it.
Case number 19-6347, John Does versus Deborah Holland et al. Argument not to exceed 15 minutes for the appellant and 15 minutes to be shared by the appellees. Mr. Robert Barnes, you may proceed for the appellant.
Thank you. For the court, to the Honorable Court, I'm Robert Barnes. I represent the John Does. I would request 4 minutes for reply.
All right. You may proceed.
Thank you, Your Honor. This case involves an unprecedented question, which is whether the Westfall Act expanded congressional immunity to effectively make election to Congress a license to libel.
All right, I'm going to stop it here. I was actually going to do like a sort of commentary running through the video, cutting out certain sections, adding my insights, but there's no way of editing audio without being accused of deceptive edits, without doing an injustice to the actual hearing itself. So I'm just going to run the entire hearing, beginning to end, no editing, and listen to it. It's amazing. It's amazing to listen to an actual hearing of lawyers and judges. Pay attention to the questions the judges ask the lawyers. No more. No, don't give me another ring pop. You crazy? Please. Listen to the questions the judges ask the lawyers. Listen to how the lawyers talk. Lawyers, they make an effort to talk slowly, clearly, concisely. All three lawyers did a very good job. But when you listen to the third lawyer, I think it's Deborah Holland's lawyer, you'll notice that it sounds like he's reading a little bit more than talking, so it doesn't exactly roll off his tongue.
Talking to the city.
I'm talking to the city? I'm talking to the world. All right, so enjoy the audio, give it a listen, just sit back, relax, and listen. I'm gonna post a picture of the Robert Barnes while you listen to the audio. Listen to it, it is insightful, you're gonna learn, you're gonna get the experience of what it's like to be a lawyer. Okay, back to the video, and have a good weekend. Oh, and incidentally, I'm doing a live stream with Robert Barnes Sunday, the Sunday after this video, which is June 14th. June 14th, I'll post a link to that right here. Tune in, it's gonna be awesome. Yeah? Okay, back to the video.
In this particular context, several facts are pertinent at this pleading stage of the case. I represent a group of minor children, kids from Covington, Kentucky, who were defamed by the two defendants, leading to their doxing, leading to threats to dismissal from their school, denial of admissions to college, and ultimately death threats that required them to take extraordinary private security action. The Senator Warren did not make her statements in the Senate, to the Senate, or at the Senate, nor were her statements concerning any matter pending before the Senate, either legislation or hearing or investigation, nor were Senator Warren's comments in response to any press inquiry or about herself personally. In the same capacity, Congresswoman Haaland, also like Senator Warren, sued in her personal capacity, not her official capacity, did not make her statements about the plaintiffs either in the House of Representatives, to the House of Representatives, or at the House of Representatives, nor was it
not a speech and debate clause case. Why would it be unusual for Congress to exempt itself from any potential liability? Congress is pretty good at exempting themselves from a lot of laws, frankly. Why would it be unusual that they exempted themselves here like they did a whole bunch of other government agents?
There would be two unique aspects of it, Your Honor. First would be that the U.S. Supreme Court, in interpreting the Westfall Act, did not interpret the act as expanding immunity. It interpreted it according to the Lamagno case at 515 U.S. 417. The U.S. Supreme Court said the act was simply to, quote, return federal employees to the status they held prior to the Westfall decision. That is why the speech and debate clause jurisprudence has relevance. Congress might have decided to try to expand and include their liability for personal liability. That's what I believe is unique here, is that the scope and scale of the immunity determined by the district court was not limited to official duties or legislative duties. It basically made it so that Congress was saying we're now personally immune from any personal torts we commit, even when we're sued in our personal capacity, even if it doesn't relate to legislative duties. Now, the question of could they have done so, our first argument is that they did not, in fact, do so here. There's no legislative
for a representative member of Congress, legislative duties probably sweeps quite broadly. Not only is virtually any issue an issue that could come before them, but because they run for election, even personal matters are sort of part and parcel of their duties. It's kind of hard to draw the line on where would you draw the line on when those duties end and something is no longer covered by the act.
Yes, Your Honor. There we believe jurisprudence like the Proxmire case from the U.S. Supreme Court is very helpful. At the Proxmire case, which is 443 U.S. 111, at page 133, went into an extended conversation about what is really part of the legislative process. And what it noted was that informing the public is not part of the legislative process. So they said, and in particular, this related to the decision they had made in the Gravel case.
That's hard to believe. Certainly members of Congress have the right to. This is what they do. And now we have social media, so they do it even more frequently. But that's a pretty critical feature of their job. I suppose there's not much public or legislative interest in the matter that happened in Washington I think it was the Lincoln Memorial. I could see drawing the line there that this matter really had nothing to do with policy or legislative business or election.
Yes, Your Honor. And in fact, the only decision cited by the defendants for interpreting the Westfall Act as expanding immunity involved a usually response to a press inquiry about a matter of either proposed legislation, pending legislation, a investigative hearing concerning legislation, or something about the congressman personally that related to their reelection and was of concern to their constituents. In this particular context, that is not what happened. The statement wasn't limited to constituents. It wasn't concerning pending or proposed legislation. It wasn't concerning the congressperson personally. And even the Operation Rescue case, which was the first case to make this sort of expansive interpretation, all of these being out-of-circuit cases related to this circuit, noted that if the statements by Senator Kennedy had been gratuitous, in other words, not in response to a press inquiry, and made purely for or had a personal motivation for personal enhancement, then the statement likely would not have been subject to immunity. Here, that's where I think there has to be some limits. If there's no limits, then essentially election to Congress gives a degree of personal immunity that no act has previously done. In addition, in that capacity or in that context, we have also the Kentucky law that the district court did not fully address, which dealt with it, which was consistent to this court's decision in Coleman, which outlined the scope of a duty relating to where the statement was made, when the statement was made, whether it furthered the purpose of the employer. And in this context, in Kentucky in particular, aside from generally saying that should be a scope of duty should be a jury question, it noted that if it was to advance a personal interest, if the statements had a motive that deviated from the official interest of the employer, then it was an intentional tort, then there was no longer within the scope of the duty for those purposes. That corresponds to the logic used by the Proxmire and Gravel Court, as well as to the Operation Rescue decision, which says we have to evaluate motive. That's often going to be a jury question, at least a discovery question. And that was the other reason we believe that the case should have moved past the pleading stage of the case.
Your friends on the other side might say that in this exchange that happened in Washington, that there was some discussion about the wall, whether that was a good or bad idea, that some people may have been wearing hats that had a political affiliation, and that there may have been discussion of some public policy matters. So why doesn't that sweep this into something that touches upon legislative issues or something touching public policy that you'd expect a member of Congress to be speaking about?
Well, two parts there, Your Honor. One is I see that more as a summary judgment question. In other words, if they could show that the issue concerned some matter of pending legislation or proposed legislation, and that was their nexus, was to tie it into the wall, and that was the motivation for the person's statements, then they might be able to prevail at the summary judgment stage on the immunity question, the scope of duty question, but not at this preliminary stage where our allegation is that it totally concerned private matters of private citizens, in this case, minor children from Kentucky, that was about attacking them personally and denying them the benefits of things like public. The goal was to deny them actually college admissions in terms of the social media lynch mob that formed around the two defendants, which they helped lead.
Counsel, would you concede that the defendants were commenting upon areas of public interest and that those areas of public interest might wind up as subject of legislation before the Congress?
Not at this stage, Your Honor. I believe they may have an argument on that they may be able to establish by the summary judgment stage, but it's our contention that they were making statements about these private citizens concerned to people in Kentucky with the purpose, the motive, not to impact any degree of legislation, but rather to hurt these individuals and to elevate themselves personally in terms of celebrity, reputation, presidential campaign, maybe in the case of Senator Warren, but not for the purpose of any proposed or pending legislative matter.
All right. Do you have anything further?
I'll reserve the bulk of my time, for the remainder of my time, Your Honor, for reply.
All right. We'll hear from opposing counsel.
May it please the court, Uzoma Nkwanta on behalf of Senator Elizabeth Warren. I will address the grounds for dismissal below, including sovereign immunity and the Federal Tort Claims Act. And counsel for Congresswoman Holland, Mr. Brooks Hanner, will address the alternative grounds for dismissal.
All right.
I'll start off with a question that Judge Radler raised, which I think goes to the crux of this matter and highlights the fundamental flaw in the John Doe's argument. The question was whether this is a speech or debate clause case, and the answer is, of course, it is not. This case in the district court's order was driven by the application of the unambiguous terms of the Federal Tort Claims Act and the Westfall Act, which amended the Federal Tort Claims Act. Now, the John Doe's arguments are completely untethered to the actual statutory language. And when you look at the statutory language, it's clear, first of all, that the act applies to members of Congress. Even before looking at the definition of employee, I'll point out that of all of the courts that have actually considered the application of the Westfall Act to members of Congress, they have all universally found that the Westfall Act applied to members of Congress. Now, if we want to get into the statutory language, the Westfall Act specifically refers to employees, and that's in Section 2679. And in Section 2671, that's 28 U.S.C. 2671, the statute defines employees to include both employees and officers of both the executive branch and the legislative branch. In other words, there has been no dispute among courts deciding this issue as to whether it applies to members of Congress. And the statute...
If we agree with you that it does apply, is there another case that has applied the rule in this context? I mean, we have the case, the Fifth Circuit, but the case where the candidate's going to be on the ballot and he has a marital issue and he wants to speak about that. We have Senator Kennedy speaking about, I think, abortion issues, which are pretty prominently in the news and certainly a legislative matter. But this is a little different than that. This was, sort of a dispute between a couple of private citizens, not something that was going to be legislated over. It did happen in Washington, but I don't know that matters. Is there a case that speaks to these facts?
I think a number of cases speak to these facts, although the cases obviously involve different factual scenarios. But I think all of the cases demonstrate that the nexus between the allegedly defamatory statements and the scope of employment is not necessarily one that has to arise from legislative duties on the House or Senate floor. So if we look at the Cass Ballinger case, for instance, Council for American Islamic Relations v. Ballinger, there Congressman Ballinger made statements to a reporter regarding his marital separation, and in discussing his marital separation, he allegedly made defamatory statements about Council for American Islamic Relations. Now, the nexus that the DC Circuit drew in that case was that his ability to explain his marital separation allowed him to become more effective, or allowed him to preserve his effectiveness as a legislator, because those were issues that his constituents would be concerned about. And if we look at the spectrum of cases in which courts have found members of Congress to be acting within their scope of employment, this case actually comes much closer to legislative acts, and for a couple of reasons that are actually identified in the John Doe's complaint. For one, the John Doe's accuse Senator Warren and Congresswoman Holland of implying that they were chanting "Build that wall" or "Build the wall" toward a Native American elder. Of course, the phrase "build the wall" implicates a specific policy relating to the construction of a border wall along the southern border of the United States. And that specific policy had been before Congress and had been disputed, had been a source of debate for quite a while, specifically with respect to the funding of the wall. So it's not unexpected, nor is it unusual that a member of Congress would weigh in on individuals.
Did the tweet say anything about the wall in it?
Sorry.
Was there a tweet itself that commented on this, and did that tweet itself say anything about the wall?
The tweet itself did not say anything about the wall. The tweet linked to a video in which the Native American elders accused the students of chanting "Build that wall," and then Senator Warren's tweet stated that the elder, Nathan Phillips, endured hateful taunts with dignity and grace. But there
is there any what are the limits? What's beyond what's outside the act, Westfall Act? Is there anything? Maybe it's sometimes determined by state law, and state law might vary from state to state, of course. But what can't a member of Congress do? What can't they say?
As I sit here today, one thing that would come to mind is if a member of Congress went into a restaurant, for instance, and said that the food is undercooked, or stated something personal that was entirely personal and had nothing to do with any matters of public interest or any matters before Congress, or had nothing to do with advancing their ability to remain effective. Notwithstanding that, we fully accept that at some point the court is going to have to define the boundary between what's within the scope of employment and what's not, and the immunity cannot be limitless. We accept that. However, this is not the case to define that boundary, because the conduct alleged here, even within the scope of plaintiff's allegations, the John Doe's allegations, is squarely within the sphere of conduct that's within the scope of employment of a member of Congress. You not only have the build the wall references, which implicate specific policies, you also have the alleged harassment of a Native American elder. And it's no secret that Congresswoman Holland and Senator Elizabeth Warren have been deeply involved in issues relating to Native American rights and have proposed legislation, co-sponsored legislation on those issues as well. So we have issues that are directly related to the interests of their constituents and that are directly related to their scope of employment.
Is there a reason why these issues should be resolved at this level as opposed to a little bit of factual development? All the things you just said may well be true. This may have been motivated by immigration policy and policy towards Native Americans. But sometimes those are fact issues. Is there a reason why, because this is a jurisdictional issue for sovereign immunity, that these issues routinely should be resolved at the threshold level?
Yes, Your Honor. These issues should be resolved at the threshold level because the Westfall Act and the immunity it confers is not just an immunity against liability. It's also an immunity against suit and against the burden of suit and defending against that suit. So to engage in discovery, as opposing counsel suggests, would elevate the assessment of the immunity itself in a way that would undermine the purposes of the Westfall Act to begin with. And the D.C. Circuit actually rejected the approach that opposing counsel suggests here in Wetterich v. Murtha, where plaintiffs' counsel sought to engage in discovery in order to develop evidence that would demonstrate that the legislator was acting in his personal interests. What plaintiff's obligation is here is to identify or present allegations to show that this was outside the scope of their employment, and they have not done so.
Is there anything different? I mean, the point you made about immunity from suit, we hear quite a bit in qualified immunity cases, yet we allow quite a few of those cases to go to summary judgment. They often do get resolved there, but is there something unique about sovereign immunity for federal employees that would require that we are more likely to decide a case at the threshold level as opposed to a sort of run-of-the-mill qualified immunity case for a state officer?
Yes. Well, in addition to the fact that it grants him, in addition to the fact that it provides immunity to federal officials, it's also jurisdictional. And if the plaintiffs cannot demonstrate, based on their allegations, that their claims fall within an exception to the FTCA or their claims are not covered by the Westfall Act, then the court lacks subject matter jurisdiction over these disputes, and the court is required to address issues of subject matter jurisdiction at the threshold level before wading into the merits. So, in addition to the burden that it imposes on the federal employees, it's also a jurisdictional issue that this court must confront at the outset. And before I see that my time is almost up, and before
counsel, does this cover any tweet or posting that relates to anything that's of public interest, even if there's no legislation at issue?
I don't necessarily think it always goes that far. I think what would be missing from such a hypothetical is the nexus between the communication and the legislator's scope of employment. So I don't think it's necessarily the case that every single tweet about an issue that may be of interest to the public is covered by immunity, but I think it's the case that when there is that nexus between the communication and the scope of employment, that then determines whether the immunity applies. And that's determined on a case-by-case basis. But
I mean, if you take out this build the wall business, does that affect your position? Is it dependent on the fact that they supposedly said that?
I think you also have the Native American elder and the harassment of the Native American elder, which also implicates their legislative agendas as well. But if you take out those two issues, and you simply take out the Making America Great Again hats, you take out the Build the Wall, you take out the harassment of the Native American elder, then I think you have a different case, and that would require a different analysis of the surrounding facts and the nexus there. But it's difficult as we sit here to see what would be left of that tweet if you take out all of those different elements.
So if, let's say, legislators were tweeting about what happened in Buffalo, or what's happening anywhere, is that protected?
I think it can be. I think it depends on the nature of the tweet, and it depends on which officials are posting the tweet. So, without additional facts for that hypothetical, I'll add an example. If there was a tweet that said the gentleman in Buffalo was planted there, for instance, would that by itself constitute a communication that's protected by the Westfall Act? Based on those facts alone, I don't necessarily think it would. I think what would be missing from that hypothetical is the nexus, again, between the claim against that individual and the scope of employment. And in this case, I think what we have done is we have demonstrated that nexus, because it is clear from the facts of this case, even from plaintiff's complaint, even from the John Doe's complaint, that there is a nexus between the scope of employment of legislators and the acts that were at issue here. Now, again, there is a fine line to be drawn so that this immunity does not become limitless. And that is something that a court, and this court even, may be called upon to do at some point. But this case is not the avenue to draw that line, because this case is so far along, and it's so clear, the nexus between Senator Warren's tweet or Congresswoman Holland's tweet and the government policies implicated, especially building the wall on the southern border, the harassment of the Native American elder. That formed the basis of the district court's opinion, and that's evident from the face of the complaint. And drawing that border and that distinction between limitless immunity and the scope of employment is an issue that is not it does not drive the outcome of this case. And lastly, before I turn it over to Mr. Hanner, I just want to also point out that the fact that there may have been some personal motivation here without conceding that there was, the fact that there have been some personal motivation does not take this case outside the scope of employment, does not take this outside the Westfall Act. numerous courts have recognized, including the D.C. Circuit and the First Circuit and District of Massachusetts, numerous courts have recognized that the personal motivations and the scope of employment of a legislator are not subject to neat separation, such that it is not unusual for a legislator or member of Congress to believe that their personal success, their reelection, or their ability to advance their agenda serves the public interest and serves their constituents. If they did not believe that, then they likely would not be running for office. So for all those reasons, we ask that this court affirm the district court's ruling, and I will turn over the rest of my time to Mr. Hanna.
Thank you. Mr. Hanna?
Thank you, Your Honor, and may it please the court. My name is Brooks Hanner, and I represent Congresswoman Deborah Haaland of the 1st Congressional District of New Mexico. Briefly, to piggyback on Mr. Nquanta's arguments, Congresswoman Haaland agrees with Senator Warren's legal arguments on sovereign immunity, which apply equally to Congresswoman Haaland, one of the first Native American women members of Congress, who was sued here for her comments
We having an
about a highly
audio problem?
publicized confrontational rally in Washington, D.C. As indicated in our brief, I'm sorry, Your Honor, I'm having a little bit of internet problem. Would you mind repeating your question?
Oh, you did have a problem, but you're back. You're back now. You're good.
Okay. I've been having problems throughout, so please jump in if I'm choppy. As I was saying, as indicated in our brief, she made these comments within the scope of her office as an elected member of Congress, and she is therefore immune from John Doe's suit. And I would like to pick up on a question that Judge Radler asked about the difference between qualified immunity and absolute immunity under the Westfall Act. This was discussed by the D.C. Circuit in Murtha at page 386 and the Supreme Court in Osborne versus Haley at 252 to 53, which is that the immunity under the Westfall Act provides absolute immunity from common law tort claims, unlike qualified immunity, which, as the court explained in Osborne, makes it all the more important for a court to deal with immunity issues as soon as possible, lest the protections of the immunity dissipate while the court's considering the issue. Unless the court has further questions about that topic, I'd like to briefly cover why the court can also affirm for lack of personal jurisdiction. Although I'll focus on Congresswoman Haaland and her tweets, the same legal framework would apply to Senator Warren and her tweets. The John Does have failed to plead jurisdictionally sufficient facts because Congresswoman Haaland's tweets, which do not mention Kentucky, name any Kentucky resident, refer to conduct that took place in Kentucky, or call upon Kentuckians to take any action, are her only relevant connection to the Commonwealth of Kentucky. Although the district court did not reach this issue, the lack of personal jurisdiction is clear from the four corners of John Doe's complaint, and it presents no complex questions of state law. Under Kentucky law, a plaintiff who wants to sue an out-of-state defendant must first comply with Kentucky's long-arm statute. This personal jurisdiction analysis entails a two-step process. First, a court must determine whether the cause of action arises from the type of conduct enumerated in the long-arm statute, and if the answer is yes, second, whether the exercise of jurisdiction would offend the defendant's federal due process rights. This second step is not necessary if a plaintiff cannot first show that the long-arm statute has been satisfied. The long-arm statute imposes a stricter jurisdictional limitation than the federal due process clause. Here, John Does have failed at step one of this analysis. Their complaint includes no allegations that Congresswoman Haaland has traveled to Kentucky, operates a business in Kentucky, derives revenue from business activity in Kentucky, owns property there, or undertakes any regular activity there. Nor does the complaint allege, importantly, that she sent her tweets from Kentucky. John Doe's complaint shows they're attempting to sue Congresswoman Haaland in Kentucky based only on communications that were not sent from Kentucky.
You can see she could be sued in New Mexico, maybe Washington, D.C., but not in the Commonwealth.
I think more discovery would have to be undertaken if that were an issue. But the way that John Does have pleaded their complaint, there are no allegations that Congresswoman Haaland was in Kentucky. Therefore, there's no jurisdictional basis to hail her into court here.
The allegation is that she caused effects in Kentucky, right?
Correct, Your Honor. Which might be sufficient under the long-arm statute if she also conducted business in Kentucky or undertook regular activity there. But if in a situation like this where a defendant has no other connection than the allegedly injurious act, that's not enough to satisfy Kentucky's long-arm statute.
Okay.
And I would point the court to, among other cases, Doe versus Griffin, which was written by Judge Bertelsmann, the judge who issued the order that John Doe's now appeal, which cited numerous cases for this principle.
I believe you're out of time. I think you're out of time, Counselor.
Thank you, Your Honor.
Thank you very much. We'll hear rebuttal if there is any.
Thank you, Your Honor. First, as to the personal jurisdiction question, the allegation here is consistent to the Calder case, but it goes beyond that. The allegation is that each of the defendants made statements directed at Kentuckians, were sent to Kentuckians. Your Twitter page, you can limit who you communicate to if you want. They chose not to. They had many Kentucky followers, both of them, communicated about Kentuckians, directing it at Kentucky, noting that the where they were from is referenced in the article in the attachment of the tweet, and calls for bad things to happen to them is relevant right directly in Kentucky. So it's not just a matter of causing effects in Kentucky. It's intent, according to the allegations of the complaint, it's intending to cause those effects in Kentucky. And under both Kentucky law and due process jurisprudence, in Kentucky, the tort of defamation occurs there if someone intends to have the action take place there. In other words, if they either send communications there, intend to cause the effects, not just happen to cause the effects. And that's consistent with also due process jurisprudence. Best way to think of it is if I'm across the state line and I take a rock and I throw it across the state line and I hurt somebody in that process, I don't get to say, well, no, I was standing on the Tennessee border when I did that. That is not the law in Kentucky or the country. Secondly, as to the issues, the big core issues of the big question in the case, does the Westfall Act apply in almost a limitless manner? And the way the district court effectively enforced it, there the Kentucky Supreme Court's decision in Blair is particularly pertinent, and it is consistent. The Blair decision can be cited at 172 Southwest 3rd, 361, Kentucky Supreme Court 2005. At page 309, they discuss this in detail, that when there's a question about personal motive, when whether a person deviated from their official purpose, in this case the legislative purpose, in any level, then that is and it's an intentional tort that's alleged, then they're not immune. It's not within the scope of their duty. I don't believe that the scope of duty laws were the same in D.C. or Massachusetts, though I would note the district court in Massachusetts went out of its way to say that statement by Senator Kennedy was not made gratuitously. It was made in response to a press inquiry for people who are going to report back to his constituents, and it did concern a matter of proposed legislation. The key question is,
so I want to ask you the same question. So if legislators were out tweeting about what's going on all over our country, are those tweets covered or not?
No, Your Honor. Our position is just because it's a matter of public interest that they may be discussed, and we're alleging that this was not a matter of public interest. But even if it was a matter of public interest, that is not sufficient to give them immunity. It still needs to be have a nexus to a legislative purpose. So if it's about pending legislation, proposed legislation. So, for example, aspects of the George Floyd case there's federal pending legislation concerned. So their commentary makes sense. The Buffalo case, I think, would be trickier. I think if they deliberately lied, like I believe the president may be subject to suit if he made a misrepresentation.
You make it sound like a congressperson could confer immunity on themselves by introducing a bill in Congress.
Well, my view, Your Honor, is that the Proxmire gravel set of decisions for determining scope of duty in the speech and debate clause context provides our best guidance. And so I would go further than that. I would not say that just introducing legislation would be sufficient. And then if the statement did not have a nexus to true legislative purpose. So is my own view. Now, I think as a practical matter, under the current interpretation of the statute, that they likely could immunize themselves simply by proposing legislation. That's why I believe the Proxmire set of decisions by the U.S. Supreme Court with the Gravel decision, and that's consistent with how they interpreted the Westfall Act. They interpreted the Westfall Act as just restoring the immunity that previously existed, not expanding it. And to go to that question, that it would raise constitutional questions. Hereby, for example, we don't even have the Attorney General certifying that this was within the scope of the duty. That's a unique factor about this case. They didn't even request it. They didn't even ask the court to determine it, presumably because they knew the Attorney General would say it's not within the scope of the duty. But that particular executive check on the process was not employed here, and I think is also a pertinent factor. But in the broader context, there are constitutional questions, as the Chastain v. Sundquist decision raised, about could they do what Your Honor is talking about? Could they just basically personally immunize themselves? Could they personally immunize themselves from crimes as long as they just propose legislation concerning my bribery on June 22nd, 2009? I think not. I think that the Proxmire line of logic that it really needs to be related to a legitimate legislative purpose is the meaningful limit we have to have for scope of duty. And I would note other state Supreme Courts applying it scope of duty in the legislative context, like the Glazier decision in Montana, they similarly said it needs to be connected to a legislative duty, a statement made on the legislative floor, a statement made in the capacity of true legislation. If there was a personal motive, going back to the Blair, Kentucky Supreme Court decision, like the fact scenario Your Honor is describing, they would not be immune because they have a personal motive that deviates from the legislative purpose, and as an intentional tort would not be immune.
All right. Does that complete your argument?
Yes, Your Honor.
Okay, thank you very much. And the case is submitted, and that concludes our proceedings.